it's our realtor members or our affiliates, associates, friends, family, etc. We are so pleased to be able to bring to you to the town hall our very good friend, Mr. Gov Hutchinson. Gov is an assistant general counsel of the California Association of Realtors. Gov has been with CAR since 1985 and manages CAR's member legal services program in Los Angeles. Gov advises realtors through the hotline on all aspects of real estate law, and he trains and supervises other hotline attorneys. Gov received his bachelor's degree in history from Princeton University and his Juris Doctorate from the University of Pennsylvania. He has written for California Real Estate Magazine, co-authored CAR continuing education courses, and is a master instructor for the Education Division of CAR with certification from the California Department of Real Estate. He also regularly speaks to associations and boards of realtors, affiliated trade associations, city and county bar associations, and major real estate firms. So that's the official bio. I just want to add in that Gov is the man. As long as I can remember, Gov has come to our association at RAM at least once a year and brought us tons of updated information from CAR from both legal and risk management standpoint. He is a friend and an ally to the Rim of the World Association of Realtors, and I'm so very, very pleased to welcome him. So Gov, thank you for joining us. The floor is yours, sir.
All right, good to be here. You may have heard her mention that I started in 1985, 35 years ago, as of a week ago. And in my 35 years at CAR, I think the last 2.5 months have been the craziest of all those years. And I'm sure it's crazy for some of you too. We're in a different environment right now. It's not going to be like this forever, and it's starting to change already. But the main thing, obviously, I'm going to talk about today is the way we got to do real estate in the COVID-19 era, however long it's going to last. Hopefully, not too much longer. But we got to deal with certain things. Okay. To back up, 10 weeks ago, believe it or not, it's been 10 weeks since this all started. Remember the very first week, real estate was not an essential service. Remember that? And then that changed real quick, but that's good. Real estate became an essential service, but not real estate to do anything you want the way you used to. You have to follow certain protocols. And what happened was 9 weeks ago, the governor issued this order and incorporating these federal guidelines, and the federal guidelines said you're essential. That's why you could do your job. So, but they said, oh, you have to follow all these CDC protocols and these federal infrastructure protocols. So we put that all together in these best practices document. And we also created this form called the PEAD form. And basically, that was our attempt at CAR to try to turn the governor's order into rules that you could follow so you were sure you were following the rules to be safe. Okay, about a week ago, actually about a week and a half ago, the state itself finally published their own guidance. So remember, the last 2 months, the governor's order incorporated federal rules. So that's what we were following. But the state itself didn't have any particular rules. Now they do. And that's the first thing I want to talk about. Now, the funny thing is, not funny, they pretty much, their rules, they took the best practices that CAR created and turned them into rules. So there's really not much you have to change in your life that you've been doing the last 2 months. The big picture is, all along we've been saying the PEAD form is a really good idea. Well, now the PEAD form is required. In other words, the state law says you have to get your buyer to sign some document agreeing to follow the rules. Now, theoretically, you guys, any office could come up with their own PEAD form if they want to, but you got to have some form that the buyer signs agreeing to certain rules. So if you just want to make it simple, just use our PEAD form. You've probably already been using it the last 2 months. Just keep using it. And by signing that form, but it's no longer recommended, it's now required, okay? That you must sign a form where the buyer's basically saying, I promise to follow the rules, and I promise to write down if I'm sick or if I have any symptoms or if I've been in contact with someone who's sick. As far as I know, I'll disclose that. Otherwise, I agree to follow the rules. So the buyer signs that form, and the buyer should sign it every day. I mean, let's say I'm a buyer, I want to look at some houses today. I'll sign that form dated today, and I'll give that form to every listing agent I see today. Tomorrow, if I want to see the same house or other houses, I'm going to get a new form because it's got to be dated today, because your health situation may change from day to day, right? So buyer needs to sign that form. It's got to be dated today, give it to the listing agent. And this applies to the buyer, buyer's agent, inspector, appraiser, stager. I don't care. Whoever's ever coming on the property, they should sign the form, give it to the listing agent. The seller and the listing agent should also sign a form. Basically, they only have to sign it once, unless their health changes. And if they want to show it, and if the buyer wants to see it or the buyer's agent wants to see it, you should show it to them. But it's not like you have to give it every time to the buyer's agent. So the buyer's agent and the buyer have to give one to the seller, the listing agent. Listing agent should sign their own, and if I'm a buyer and I want to see it, show it to me. If I want a copy, give me a copy, but it's not actually required. So one thing that's going to change this week, slight change, because these rules, the guidance changed slightly. The state rule slightly changes the rules we've been operating on. So we have to slightly change the PED form. And there's also going to be a buyer's version and a seller's version. Right now, as you know, there's just one PED form. People who are entering the property sign it. People who are living there sign it. But it's going to change probably the end of this week. There's going to be a form for visitors, buyers to sign, buyer's agents, and there's going to be one for the occupant, the seller or the tenant who lives there to sign. They're going to be very similar, but that's it. And they've changed a couple rules. You know what's no longer required? Gloves. I'm not saying you shouldn't wear gloves when you see a property, but basically, you know what the rule now says? It says, before you enter the property, either wash your hands or disinfect or use hand sanitizer. So what's really supposed to happen now, and this just as of this week, is the buyer obviously should be prepared, but if not, the seller or the listing agent should have available, when the buyer or the buyer's agent shows up, hand sanitizer so they can wipe their hands. Now, let's say you don't have hand sanitizer. Well, the other choice is they can wash their hands. But to me, I think it's better, right? Do you want them actually coming into the house with dirty hands, going to the sink or going to the bathroom and washing their hands? I think it's a better practice as a listing agent to have the hand sanitizer, to give it to them before they come in the door, and then they're good. What about the gloves? Gloves are not required anymore. That doesn't mean it's not a bad, I think it's a good idea to hand sanitize your hands and put on gloves, but they're not required. I guess the seller could require it if they want to. Yeah, I really want you to wear gloves, but it's no longer required by the rules as of this week. Cleaning or hand sanitizing, that's required. Otherwise, and then you're good. But once you're in there, it still says try not to touch anything, right? Whether you got gloves on or not, ideally you shouldn't be touching stuff in the house. And you know what the new rules say? It says seller, before people come in for the showing, you should open all the doors and turn on the lights so people don't have to touch doorknobs or touch light switches. That makes sense. So that's sort of a new thing this week. But other than that, it's pretty much same thing, you know, one buying party at a time. No open houses, one buying. I mean, you could have a bunch of different buying parties, one right after another, but the seller is supposed to clean the house or, you know, do some type of cleaning and disinfecting after each showing. You know, wipe down the surfaces and wipe down the doorknob and wipe down any banisters or handrails. And you're supposed to do that after each showing. Okay, so to me, I don't know how you do an open house if you're limited to one buying party at a time, and after each buying party comes in, the seller or the listing agent has to, you know, wipe down the property, clean and disinfect the property. So it's still limited. The only thing that's really changed is the glove thing and booties too. Don't worry about foot coverings or booties. No one has to wear those unless you want to. The mask is still required, and standing 6 feet apart is still required. And signing the PED form. I mean, what should really happen is the buyer, anyone entering the property, should sign the PED form electronically and email it to the listing agent before you even get there. Then when you get there, you go into the property. Sanitize your hands or wash them before you go on. You don't have to wear gloves if you don't want to, unless the seller wants you to. And then once you're in there, stand 6 feet apart and don't touch stuff, right? Basic stuff. Now, there's one other new thing. You are required, let's say I'm a seller and I'm having a showing. I'm required to post on the entrance, like the front door or next to the front door, a PED form, a blank unsigned PED form, and a pictogram that we emailed to all of you guys, I guess Friday. So if I'm a seller right now, right, and I'm listing my house, and my agent, we arrange for a showing, an appointment, everything should be by appointment. During the actual showing itself, right before they get there, I'm going to post on the front door a blank PED form and that pictogram thing we sent you on Friday, 2 different things. But to complicate your life, that's going to change by the end of this week. We're going to create a new form, which includes the pictograms and the rules, but it's different than the PED form. So whenever that happens, probably by the end of this week, you're only going to be putting one thing on the front door. It's going to be a combination rules and PED form. Rules and pictogram. And you might have noticed that the pictogram we sent you Friday, one of the pictures has a picture of gloves. But that just changed. So we're going to change the pictogram so it's not going to have a picture of gloves anymore, because gloves aren't required. Like I said, if the seller listing agent says, I don't care what the rules are, you're not coming in my house unless you're wearing gloves, that's their business. You can say that. I'm just saying the state rules no longer require gloves or booties. So I know it's kind of complicated. Probably be better if I were here next week. But so we got the rule for today. We got the rule by the end of the week. The rule for today is, if you're showing a property, post on the front door a blank PED form and the pictogram thing we sent you Friday. By the end of this week, the rule is going to be, we're just going to post the new pictogram, which is going to include the rules on it. So the buyer is still going to sign a PED form and email it to the listing agent. Listing agent and seller, you're still going to sign your own PED form and keep it. And if anyone wants to see it, you're going to show it to them. But the thing that's going to be posted on the door is going to be an updated combination pictogram rules document, which should be available Thursday or Friday, but maybe next week. Sorry to complicate your life, but they keep changing the rules on us. So we got to keep up with the rule. They literally change this almost every day, and they don't even tell us. The Department of Public Health, they change their guidance, and they don't even put out an announcement. So we have to check the guidance every day to see if they changed anything since yesterday. It's a nightmare, but that's the life we're living right now. It's not going to be like this forever, but right now that's what we got to do. Okay? So that's point number 1. You got all that. Second thing is, you guys are allowed to open your real estate offices now. But if you want to open your real estate offices, you got to follow certain protocols. For example, like everyone who comes in the door, you have to ask them if they have any symptoms. You have to put a barrier. If you have a receptionist, you got to put a barrier between the receptionist and the people coming in so they're not too close. You know, you have to have social distancing in the office. You can't congregate in the break room. Anyway, we came out with a legal sufficient plan. We emailed this to you, all brokers. If you didn't get it, we can send it to you or call the legal hotline, but there's a approved plan for opening offices. If you follow that plan, you're okay. But you can't just open your office like you used to, not yet. That'll probably be stage 3. But now we're in stage 2, which says you can open your office if you follow certain protocols. And we've created a template. If you follow what we suggested, you're definitely okay. And we emailed that to every broker in California last week. If you didn't get it, I can send it to you again. Okay, so we got the rules on showing properties, and then we got the rules on opening office. 2 different things. And goodness knows, you know, they'll probably change. So probably in a couple of weeks from now, we'll go from stage 2 to stage 3, and things might change again. We just got to keep up with this stuff. But stage 2 just started last week, right? So we're in stage 2. Stage 2 means you can open your offices, and they've changed the showing guidelines slightly. No gloves, no booties, post something on the door, but you're still going to sign the PED form. That's now mandatory. Okay? All right. What else do you need to know? Well, there's another good form that's not required, but I strongly recommend, called the Coronavirus Listing Addendum. If I were a realtor taking a listing, I would say to my seller, I want you to sign this addendum in addition to the listing itself. The initials for the form are the RLACAA, Residential Lease Agreement, Coronavirus Addendum or Amendment. By signing this form, you know what the seller is saying? The seller's agreeing, I will follow the rules. And if I don't follow the rules, I'm acting against your advice. And if there's any lawsuits that come out of this, if you get sued, realtor, I'll take the case, I'll indemnify you, you're covered. And it also explains that the realtor's not the police. It's not your job to police this stuff. It's just your job to tell them the rules. And you know what else it says on this form? That the seller is responsible for cleaning after each showing. You know what? If the seller doesn't take responsibility, that means the realtor's got to clean after each showing. And I know you realtors don't want to be wiping down properties after each showing. So you want to put that responsibility onto the seller. And that's why you're going to use that coronavirus addendum, which is going to put the responsibility on the seller. Okay? So is that a required form? Absolutely not. It's just a good form for the listing agent, so I recommend it. Okay? The third form I want to mention, so the PED, we all got that one down, it's mandatory. The second form I mentioned, the coronavirus listing addendum, not mandatory, good form for realtors. Third form, this one's also not mandatory. It's totally between the buyer and seller if they want it. It's called the CVA, the Coronavirus Addendum. This is an addendum to the purchase contract. You may have been using this form. This form, let's say I'm the buyer and you're the seller. And I write an offer on the RPA and I attach to the RPA this CVA, Coronavirus Addendum. This form says, and I ask you to sign it. If we sign it, we're both agreeing that if we're in the middle of escrow and there's some delay that happens because of COVID-19, the lender's delayed, the appraiser's delayed, the notary's delayed, the inspector's delayed, something happens, there's a delay. Or, God forbid, the buyer gets sick or someone in their family gets sick or the buyer gets laid off or something like that. Something happens. If we agree to this addendum up front, we are agreeing that if something happens in escrow that's either causing a delay or causing I just can't perform, we're both automatically pre-agreeing to a 30-day extension. So we don't have to negotiate the extension once the thing happens. By using this addendum to the purchase contract, we've agreed to the extension already. Now, the question is, what if the extension, so it's a 30-day extension. 30 days go by and I'm the buyer, I'm still not ready to close. I'm still missing my deadline. What does the form say? The form says, well, if you can't make the deadline, then either the buyer or the seller can cancel the whole deal if they want to, after the extension. So the next question is, if that happens and it's canceled, does the buyer lose their deposit or does the seller keep the buyer's deposit? I'm assuming the buyer has removed their contingencies. If the buyer hasn't removed their contingencies, they always get their money back. But let's say buyer removes contingencies, then they're in escrow, something happens causing a delay. That, by the way, when that happens, then I, the buyer, am going to send you a form called the NUCC, the Notice of Unforeseen Coronavirus Circumstance. That works with the CVA. So in other words, the CVA is the buyer and seller agreeing if something happens, there's an automatic extension. But we don't know yet if something's going to happen. The NUCC is the form that if something does happen during escrow, a delay or a sickness or a loss of a job, if that happens, I'm going to notify you, yep, it actually happened. And once I send you this form, that kicks in the automatic extension. But let's get back to what I was just saying. What if you still can't perform even with the extension, or maybe I just lost my job, so I can't perform at all? It says in the contract, either side can cancel. Do I get my money back or not? Well, if you don't check the box, the buyer gets their money back. If you check the box, the seller keeps the buyer's deposit. Now I know what you're thinking. Well, the buyer, I'm always going to want the part that says I get my money back. And the seller says, no, I'm not going to use this form unless I get your deposit if you default. You know what this means? Sometimes you're not going to use this form because the buyer and seller can't agree. Buyer's going to say, I'll only use this form if I get my money back. And the seller's going to say, I'm only going to use this form if I get your deposit. So sometimes there's an impasse and you're not going to use this form. Okay, so what if I don't use this form? And I'm the buyer and you're the seller, and we're in escrow with the normal contract. And a week before close, I lose my job. I get laid off because of COVID-19. So I can't close. And you're going to say, well, sorry, if you can't close, I'm going to keep your deposit. I'm going to go to court. What's the court going to say? Well, you know, there's a law in California. It's called the Act of God law. It's Civil Code 1511 that says if two parties to a contract, if you're in a contract with someone and some irresistible superhuman cause occurs preventing you from being able to perform, like an earthquake or like a fire or something, then you can get out of the deal and get your money back. So I guess the question is, are courts going to consider this pandemic that we're in one of these irresistible superhuman causes that's going to allow people to just walk away from their contracts? We don't know. And it might depend on the circumstance. If the buyer actually gets sick, probably get out of the deal. If the buyer loses their job, one thing. What if the buyer's just worried about their job, but they haven't actually lost it yet, or they've lost money in the stock market? Is that going to be grounds to cancel and get their money back? I don't know what a judge is going to say. My point is this. There's a form you can use if you want to. The CVA I just talked about, the coronavirus addendum, where the buyer and seller can anticipate these issues and decide for themselves what happens if either the buyer or the seller can't perform. You don't have to use this form. It's up to you. Okay, so those are the four forms I wanted to talk about. The PED, which you've been using, I hope, and now is mandatory. The coronavirus listing addendum, which I think is a good form for the listing agent. And then this CVA form and the one that comes with it, the NUCC, which are completely optional for the buyer and seller to use if we want. And by the way, we have the same thing for a lease agreement. It's called the CVA LR for lease rental, just like we have a PED form for a rental situation as well. So if you're showing properties for rent as opposed to showing properties for sale, then the form I would sign if I'm entering the property would be the PEADLR for lease rentals. It applies to, you know, prospective tenants and property managers and people like that. Okay? All right. Let's see, what else do you need to know in real estate that's happening right now that's not going to last forever? Well, we've got evictions and foreclosures. Here's the deal with evictions. If you got a tenant and they're not paying their rent, and the reason they're not paying their rent is because of a loss of income caused by COVID-19, you cannot evict them until June 1st. It's only 2 weeks away. But they still owe you the money. So does that mean on June 2nd, I can evict them if they don't come up with the money? It depends now. What does it depend on? It depends on the loan. In other words, if I'm a landlord and I have a loan, my property is not paid off in full, I have a loan against my property, and the loan against my property as the landlord is a federally related loan. It's a FHA, VA, or just a standard conforming loan, Fannie Freddie loan. If that's the loan against my rental property, then I have a different deadline, and I cannot evict the tenant until July 25th. If I own the property free and clear, or the loan I have against my property is like a jumbo loan or it's not a conforming loan, it's not a federally related loan, then I can evict my tenant on June 2nd. But if the loan against my rental property is a federally related loan, I can't evict till July 25th. But you know what? Who cares anyway? You know why? The courts are closed in California. They're not processing unlawful detainers till August 1st anyway. So forget what I said before. Just think about if you're a landlord, I can't get anybody out of the property until the 1st of August. That doesn't mean they don't owe me the money. They owe me all the money. They haven't been paying. I'm just delayed on my ability to evict. So come August 1st, they got to pay me or else I evict them. Unless the city or county that you live in has its own eviction moratorium. I live in LA. Do you know what the rule is in Los Angeles? The rule in Los Angeles, this eviction moratorium goes for a whole year. And even if the tenants come back sooner, they don't have to pay me the back rent until a year. And there's a rent freeze in Los Angeles, county and city. So you see what I'm saying? So here in LA, I couldn't just evict someone on August 1st. I got to give them a year to pay it back. Plus, I got to give them more time before even the eviction moratorium lasts. My point is this. I have no idea if Lake Arrowhead has a rule like this. I have no idea if any cities around you have rules like this. I doubt it, but I don't know. And I don't even know if San Bernardino County has a rule like this. I can check for you, but I don't memorize these things. So if you're a landlord wondering about your rights, we got the state rule I just mentioned, which includes the federally related loan, and that's the rule unless there's something different for you based on your county. So you might want to call the legal hotline and check and see if, or it's actually on our website. If you go to car.org and in the search box on the top, on the homepage, you type in eviction moratorium chart, it'll tell you that if there's any special rule in San Bernardino County. Yes, Paul, in LA County, it's commercial also. Yes. Okay. So that's the latest on evictions. We don't like it. It's going to change. Gradually we open up. These things will go away, but that's what we got to deal with right now. Another thing we're dealing right now is something called foreclosure forbearance. You know what forbearance is? That's a fancy word for deferral. Does that mean if I got a mortgage, I don't have to pay my mortgage? No, you absolutely have to pay your mortgage. It's just that depending on the type of loan that your property is securing, you may have the right to defer that. Let me back up. Two things going on here. First of all, in California, right now, there is a foreclosure moratorium. Not a forbearance, just a moratorium, which means if you don't make your mortgage payments, you can't get foreclosed on. How long does that last? June 23rd. Meaning on June 24th, if I have to make up all the back, I have to be current or I can get foreclosed on. But if the loan that I'm paying off is a federally related loan, FHA, VA, or conforming Fannie Freddie, not only is there a moratorium on foreclosure, I can apply for a forbearance. I can apply and the lender has to allow me to delay and defer making the mortgage payments. That's assuming that the reason I'm not making them is COVID-19 related. I lost my job, I'm sick, my tenant is not paying me, that's a COVID-19 related reason. So if the reason you can't pay your mortgage, if it's a federally related loan, is COVID-19 related, okay, not only can they not foreclose on you until the end of June, but they have to allow you to pay you back over time. In other words, they have to give you at least 12 months. And there are various options depending on your situation. They can they can do a loan modification. They can just set up a repayment plan for the months you missed. They can add those payments to the end of the 12 months, the ones you missed, Or there's a new option that some people are eligible for is you don't even have to make those missed mortgage payments until you actually sell the property or refinance the loan. It depends on the situation as to which of those options you get, but everybody gets at least one of those options if it's a federally related loan. If it's a regular loan, you just borrowed money from Wells Fargo, it's not a conforming Fannie Mae loan, you just borrowed money from your local lender and it's just a direct loan, a hard money loan, what jumbo loan, you got to pay it all back on June 24th, but they can't foreclose on you until then. Okay? So we got the rules. We've talked about so far the rules for showings, the rules for opening offices, the rules on evictions, and the rules on foreclosures. What else is new now that we got to deal with? A couple of little things. The DRE is closed, I think, for giving exams all the way till the end of the month. If you have a DRE deadline, like your license renewal is due, if your deadline is prior to July 14th, you can extend it by 60 days. So if your license renewal date is July 1st, it's now April 30th. I mean August 29th or 30th, whatever 60 days is, okay? But if your DRE deadline is July 15th, it's still July 15th. If your deadline is before July 15th, you can add 60 days to it, okay? So that's the latest with the DRE. Let's see what else you really need to know. If any of you guys are doing a 1031 exchange, remember how that works? I got an income property, I got a commercial property, I want to sell it, but I don't want to pay capital gains tax. How do I avoid paying capital gains tax? I exchange it for another property. And I'm allowed, I don't have to do this simultaneously. I can sell the first one first, and then I have 45 days to identify the replacement property, 180 days to close on the replacement property. Well, if I'm already right in the middle of that, and I got my 45-day deadline or my 180-day deadline coming up, all those deadlines are extended to July 15th, okay, for now. I don't know if they're gonna get extended anymore, okay? Disclosure issues sometimes come up. What about this issue? What if the seller says, I want to sell my house, but I don't trust anyone coming into my house, so I'm gonna do the whole deal virtually. Well, the purchase contract gives the buyer the right to physically come into the property to inspect. So if you want to do that, you'd have to do an amendment to the purchase contract saying the buyer can't come into the property. It's going to be awfully hard to buy a house that way, but you can do it. You can work around it if the buyer's okay with it. What about the realtor? Well, you've got to come in the property, do your reasonably diligent visual inspection. What if the seller says, no one's coming in, nobody's allowed in at all? How are you supposed to do your visual inspection? Well, you can't. So you'd write on your AVID form, was not permitted entry to the property. My disclosure is just based on what the seller told me, or maybe the seller sent me some videos or pictures or whatever. So in other words, you can do it. It's not that it's impossible, it's hard. And you'd have to write certain things on the AVID and you have to amend the purchase contract, but it's actually theoretically, if the lender's okay with it, if the buyer's okay with it, no inspection on the property, you can theoretically do the deal. If hopefully not many people are requiring that, but I do get that question sometimes, okay? Another thing, by the way, in this environment is, as realtors, be sure to know that you have access to a couple of federal programs where there's money for you. I mean, they're giving money to everybody else. Why shouldn't they give money to realtors? There are two programs. There used to be three. One's already over. One is called the PPP, Payroll Protection Program, and one is called the PUA, Pandemic Unemployment Assistance. The PPP is either a broker or an agent. You can apply through your local lender for a loan that you're not going to have to pay back. That's pretty good. A forgivable loan, basically to cover approximately 2 months worth of your expenses. If you're a business owner, you could use the money for payroll or business rent or business mortgage payments or utilities or stuff like that. There's limits on this, and you have to use the money by July 1st, but there's still money available, and you can still actually apply for this, and they're still giving out money for this. Or if you're an agent, you can replace 2 months of lost income by getting this forgivable loan. By the way, if you have questions on this, don't ask me. We have a hotline for this. We have a hotline. You can call up and ask questions about this program. I'll put it in the chat. It's 213-350-8450. I'm sorry, 213-351-8450. I'll put that in the chat in a second. But the other program might even be better for you guys as a realtor would be you're actually eligible for the first time in your life for unemployment. Normally, an independent contractor is not eligible for unemployment. But now independent contractors are eligible. It's called Pandemic Unemployment Assistance. We emailed to every realtor in California a step-by-step guide how to fill out the application. If you didn't get it or you have questions on the application, call that number, 213-351-8450, and they'll help you walk you through it. I know realtors who've already been getting money. In other words, obviously, if you're making money, if you're making commissions, just like you always were, you're not eligible. But what if I'm making some money, but not as much as I used to make? Well, you're eligible for some unemployment, okay? It can be up to actually, and it's retroactive back to February 1st for the first 2 months, $167 a week. But April, May, June, and July, you could get up to $167 plus $600 plus more if you're eligible. So you might want to check out that program. Call that number, 213-351-8450, to see about your eligibility for either one of those two programs, okay? Because the money's there. And if you're eligible, you should get it. Okay. I'm going to see if there are any other questions. You can start asking me any questions you want. I think I'm ready for questions. Brandy or Teresa, whoever's going to.
So, Gov, thank you so very much. What we have is we did have some questions that were submitted ahead of time.
Okay.
So ask Brandy to present those. And then if time still allows, we'll take questions from the floor. Just a reminder to everybody, if you do have a question, please go ahead and send it to Brandy privately. Don't just put it in the chat box for everyone. And that way we can be organized and we can get as many answers as possible. So with that in mind, I know that we've got questions about the current situation with COVID-19. We've got questions about virtual real estate. We've got questions about all sorts of stuff. So we're going to be all over the place on you.
Okay.
Okay. So Brandy, can you toss in the first question, please?
Okay. Some agents are leaving blank PED forms at their listings and asking agents to sign them on site. Is it good practice or should they be done ahead of time? Which do you prefer?
Yeah, they really should be done ahead of time. I mean, that's what the rules say. The buyer should sign it before coming to the, I mean, ideally, we're trying to minimize paper here that people touch. So ideally, the buyer signs it and emails it to the listing agent and the buyer's agent. By the way, the buyer and the buyer's agent can sign the same one if they have the same health situation, and you email it to the listing agent. If I'm a listing agent, I don't really want to leave it there. First of all, the listing agent, remember, everything should be by appointment only, so the listing agent should actually be there, or the seller. And do you really want people showing up and having them fill it out right there while you're waiting for them? Because you're not supposed to let them in until they sign it anyway. So I don't think that's an ideal practice. Remember, the new thing is you got to post a blank PED form on the front door, which is going to be a new form by the end of the week. And the seller, the listing agent and the seller is responsible for having hand sanitizer available when the people show up. That's a new requirement. Otherwise, they have to actually go in and wash their hands in the property, or completely optional, you can have them wear gloves, but that gloves are no longer required.
Okay, thank you. Brandy, what's the next question?
And in today's virtual format, we have photographers who use laser measuring properties to make floor plans to go with the tour. Sometimes the square footage measurements do not match county records. Which do you advise we advertise in the MLS, the county records or the more recent measurement by the photographer?
I would say either one, as long as you identify it and say, according to the county, it's this, or according to the photographer, it's this. As long as you identify where it came from, that's okay. But I'm glad you raised that, because guess what, guys? I have something to tell you today that has nothing to do with COVID-19. There is a brand new form coming out from CAR in the middle of June, which is going to address exactly what Brandy just said, and that is, it's going to be called the square footage and lot size addendum. So the initials of the form are square footage, SFLS, square footage lot size. Because this is an age-old problem. Buyers, every deal you do are going to say, what's the square footage here? And you know what? There's no answer. Everyone has an opinion, and no one's opinion is better than anyone else's. The assessor has an opinion, the appraiser probably has an opinion, the builder might have an opinion, the architect might have an opinion, the seller has their own opinion. None of these opinions are right, and none of them are wrong. So what's the obligation of a seller and listing agent? Just disclose, always say, well, you want to know what the square footage is? Well, according to the assessor, it's this. I have no idea if that's true or not. But here's the beauty of this new form. This new form has a chart on it. So it says assessor, appraiser, seller, builder. So you can write down on the form any different opinions of square footage. You give it, it's called the square footage and lot size advisory. So I'm going to give it to the buyer and say, here, look, here's what everybody thinks the square footage is. Take it for what it's worth. If you want to hire your own person to measure it, knock yourself out. Just be aware that there's no such thing as the official square footage. And here are all the various opinions. And I, the realtor, I'm not standing behind any of them. I haven't measured it myself, blah, blah, blah. So it's not a mandatory form, but I think it will be a nice, helpful form, because this is an ongoing issue. And the other thing is lot size. Of course, buyers always say, what's the lot size? You know what the correct answer is? Hire a surveyor to measure it. That's the only way you find out the lot size. And it actually says on this form, if you want to know what the lot size is, you should get a survey. In fact, if you want to know if the fence is on the boundary, get a survey. If you want to know if those bushes are on the boundary, get a survey, because there's no other way to know. So this is not a COVID-19 related form. It's a brand new form coming out mid-June. Nothing to do with COVID-19, but I like it. I think it's a good form. Okay.
Awesome. Okay, thank you. Brandy, what's the next question?
I'm pretty sure you touched base on this a little bit, but what is your take on face mask, gloves? You already said that gloves aren't mandatory, but how long do you think we will have to wear these while showing homes?
The face mask?
Yeah.
That's a very good question. I'm thinking probably stage 3 is no longer going to require the face mask. But I don't know, in this day and age, I'm probably going to be wearing face masks longer than I have to, just to be safe, you know what I mean? So I'm thinking sellers and listing agents are probably going to say, I don't care if the rules are changed, I like you wearing the face mask. My guess is when we go from stage 2 to stage 3, I'm thinking it's pretty likely they're going to take away the face mask, but they're still going to probably have the social distancing. All the so-called experts say the standing 6 feet apart is more important than the face mask. But right now, they're both still required, but the gloves aren't, and the booties aren't. Okay?
All right.
Cool.
And
Next one.
Can buyers sue an agent if they get COVID-19 after they ride in the same car with an agent who showed them houses?
Very good question. First, let me answer that by saying one of the main good things about the PED form is when the buyer signs that, they are saying, I assume the risk of going out to people's houses. I understand that some sellers aren't going to know they're sick, or other people are not going to know they're sick, and I may get sick anyway. I assume the risk, and the realtor has no responsibility if I get sick. But that's not the question you just asked. The question is, what if you'd ride in the car with them? Well, then remember the PED says you shouldn't ride in the car with your client. You should meet them at the property. So if you're riding in the car with your client, you're violating the PED. So if it turns out later that you're sick, God forbid, and you drove around your client in the car and they get sick, yeah, then they're going to probably have a case against you. I know what you're saying. How are they going to prove they got it from me as opposed from somebody else? And that's the question we're all going to see. You know, we're going to start seeing these lawsuits where people say, well, I'm suing you because you gave me the COVID virus. And you're going to say, prove it. How on earth do you prove that you got it from this person rather than this person? I don't know if any of these lawsuits are going to go anywhere. But the PED form does say you're not going to ride around with your clients. So I think you're setting yourself up for a problem if you do, if they get sick, because they're going to say, I must have been from my realtor. And you never know how a judge is going to react to that. So you're safer if you follow the rules. And then you have no then if they get sick, you're off the hook because I don't know how you got sick. I followed the rules and you agreed that if I follow the rules, you assume the risk and you can't sue me. That's why it's good to follow the rules. Protects you from lawsuits. Okay.
Next one, Brandy. Boy, we're rolling along. This is great.
Will CAR be doing any TV ads, letting the public know about any new showing rules, having a prequel, etc. before seeing a property? Buyers are likely to say, forget it, and just go to the next agent if they can't, if they get, wow, if I cannot speak, if they think someone else will show them properties.
Okay, so we're not doing any TV ads. We keep doing webinars that explains this stuff. We have FAQs on our website that explain this stuff. But let me go back to what that person was saying. Nothing in the rules says you have to limit showings to buyers who are pre-qualified. I mean, I think that's a good idea, but that's not a requirement. So I'm going back to that question. I'm wondering, you're allowed to show property to anybody. So I'm wondering what people are, the nature of that question seem to be saying if,
Yeah.
you know, in other words, you can show property to anyone you want. Or maybe what you're saying is some buyers don't want to wear the mask and don't want to stand 6 feet apart. And I refuse to show them unless they follow the rules. I think it's a good idea for liability purposes to make your clients follow the rules. But I guess if you got a client who doesn't want to follow the rules and the seller's okay with it and the listing agent's okay with it and you're okay with it, I wouldn't do it. You're setting yourself up to get in trouble. But so I'm not sure I understand the question, but that's my answer.
Maybe they meant the PED form.
Yeah, I mean, the PED form as of this week is actually required as opposed to recommended, but people still may object. I've come across inspectors, I'm not signing that form. Well, what do you do now? Well, would you at least wear the mask? And they say, okay, I'll wear the mask, I just won't sign the form. Well, then it's up to the seller and the listing agent whether you want to let them in or not. You can be a hardball and say, listen, the rules say you got to sign this form, so if you don't sign this form, you can't come in. I mean, that's up to the seller and the listing agent. Maybe you're okay with, what if they say, I'm not signing the form and I'm not wearing a mask and I'm not washing my hands either? I wouldn't let them in my house, but if the seller or the listing agent are okay with it, they're okay with it. It's not like, I guarantee, I'm pretty sure the police aren't going to come and arrest anybody for this, but you're setting yourself up for lawsuits. So anyway.
Okay, I have another one. Regarding to the CVA, if we hit 30 days and either party can cancel, do we have an issue, or do we have to issue the notice to perform first, or what do we do?
Very good question. So remember I talked about the CVA form and I said there's an automatic 30-day extension. And then at the end of the extension, either side can cancel. So the question is, before they cancel at that time, do they first have to send a notice to perform or a demand to close escrow? And guess what? There's a box on the CVA form. If you check the box, that means you do have to send the notice to buyer to perform first. If you don't check the box, then you can just go immediately to cancel without the intermediate step of the notice to buyer to perform or the demand to close. So it's actually what the answer to the question is, whatever box, depends on what box you checked on the CVA.
Okay. Can landlords charge late fees? Is it okay to serve the 3-day notice and knowing or knowing that the landlord can't start eviction process until August?
Very good question. That's several questions. If the reason the tenant isn't paying the rent is because of loss of income due to COVID-19, so if that's their reason and they can prove it, they lost their job because of COVID-19, or they're sick, or they're taking care of a sick family member. If that's the reason, don't charge a late fee, and don't even serve them with a 3-day notice until August. But for any other reason, maybe the tenant, they're not paying the rent, but it's not because of COVID-19. Or maybe they violate some other term of the lease. Or maybe you just want to give them a 60-day notice so you can sell the house to somebody else. All of those situations, go ahead and serve the notice now if you want to. Go ahead and charge them a late fee. You can do all the things, but you're just not physically going to get them out until August. But if it's a COVID-19 related non-payment of rent, no late fee, don't serve the notice, don't do anything until August. So it depends on the situation.
Okay. And I think, well, Steve, go ahead and unmute yourself.
There's no need. I'm good.
Okay.
I was going to ask Gov a question, but it really isn't the right. It's not the right. It's not the right place to do that. So.
Okay.
By the way, you see,
I'll reach out to you directly.
Okay, Steve, and you see, I put in the chat my direct email. You guys email me anytime you want. I'm not going anywhere. I have nowhere to go.
Yeah.
I spend all day answering emails, or you can call. You can call me too. And that's the relief hotline too.
So just, I want to say I appreciate you coming on, Gov, and giving us the update. I came in a little bit late, but it's always good to hear you.
I appreciate that, and I'm glad to do it.
All right. Do we have any more questions for Gov or any comments, concerns?
You got my email address. You can complaints about the forms, complaints about everything. I get all these emails from realtors saying, "Why are you doing this?" I can't keep it. I'm not anything. I'm just reporting the facts, making the forms. I don't make these rules. Okay.
Which we always appreciate, because every time you come to us, Gov, it's entertaining and it's clear and it's spoken in words that we can understand, because we're not attorneys and we don't play one on TV. So, you know. All right. So since we don't have any further questions for Gov, a couple housekeeping items. First of all, thank you, Gov, very much for coming. It's always a pleasure and a treat for us to have you. And we know that you have a tremendously busy schedule. I know that I see you in meetings almost every single day. So I know you have to run to each of us. I'm amazed you could make time for us today. So thank you, thank you, thank you. I'm sure that our membership appreciates it very much. We have been recording the session. We will get it uploaded to our YouTube channel, and we will get it out to our members so that they can replay it. And if anyone didn't make the whole session, or they couldn't make the session at all, we've got it available for our members as well. Before the meeting ends, we're going to remove everybody from the room, and we're not going to turn off the power and everything goes poof. So graceful exit from the meeting. Just as a reminder that we have Happy Hour coming up next week. Virtual Broker Tour is this Thursday at 10 a.m. Be sure to get your property on so that we can tour it. If you put your property on tour and you're not on the virtual tour session with us, we don't cover it. So if you want your property to be seen, you need to be on the call with us. And I think that's it. So those are the reminders. Thank you again, Gov, for coming. Thank you, everybody.
See you later.
Do fantastic things. Have a great week, and we'll see you at Broker Tour and at next week's Town Hall. And we're just going to keep rolling this along. Have a great day, everybody. Talk to you later. Bye.